you shouldn't wait 3 or 4 years to get your nerve up to call an attorney. We often advise people and then turn them away and say, you're not going to file a False Claims Act case, or we're not going to file one. And we give them reasons why. But often they've waited too long.
Corporate fraud works best in the shadows, behind corporate walls. How does the government bring these wrongdoers to justice? Whistleblowers. These are the stories of those who risk their careers to shine a light on allegations of fraud. Today on Fraud in America.
Well, welcome to today's episode of Fraud in America. We are going to take a little bit of a different route today. I have two of my friends on who are both qui tam attorneys, but they didn't start out that way. And they're going to talk about some of the lessons they learned over the years in working at the Justice Department and how that has transitioned over to the relator or whistleblower side now that they're both qui tam attorneys. Joining us today, Renée Brooker with Tico and Zafari, LLP in Washington, D.C. She's a former prosecutor and senior leadership at the Department of Justice. She was responsible for billions, yes, with a B, of dollars in recoveries under whistleblower laws. Specifically, she was one of the former assistant directors of DOJ civil frauds. She was on various task forces, including DOJ Financial Fraud Enforcement Task Force. She led a team to a successful civil RICO verdict against the tobacco industry after a 9-month trial. She is a Philadelphia native, graduate of Temple University, and is a fellow Hoya Loya, graduate of Georgetown Law School. Renée, welcome to the show.
Thank you so much for having me, Jeb. I really appreciate it.
Absolutely. Also joining us from Texas is Josh Russ of Reese Marcatos, LLC. He is a graduate of the University of Miami, and then he decided to fly all the way across the country and go to law school at UC Berkeley. And then we forgive him for this. He did spend some years at a big law firm doing healthcare regulations, defense work, and then found his way home to the plaintiff side in 2013 when he joined Reese Marcatos, LLC. And then in 2015, he decided to round out his resume by going to the government. So playing all three sides here, went to the Eastern District of Texas. And at the age of 33, in the year of 2018, he became the civil chief in the Eastern District of Texas, where he supervised all civil litigation cases out of the U.S. Attorney's Office in the Eastern District of Texas. He was also co-chair of a national prescription interdiction and litigation task force working group going after the opioid crisis that has gripped this country. And then in November of 2019, he rejoined Reese Marcatos and became a partner of the law firm and heads up their False Claims Act qui tam practice. Josh, welcome to the show.
Thanks for having me, Jeb. Happy to be here.
This is going to be a lot of fun. We've had a lot of people who have worn different hats. But you both have this interesting through line of working with the government and then making the decision to go to the relator side, which seems to be an increasingly happening trend. Renée, why do you think this is happening, and why did you decide to join the whistleblower bar?
Well, I think that the relators bar is becoming more and more sophisticated and much more willing to litigate meritorious decline qui tam cases. And I think that DOJ resources are never going to be fully resourced. And so they need the relators bar to, help them carry the water and get these cases over the finish line. And I had really positive experiences with relator firms during my time at DOJ. When I worked on the AWP, the average wholesale price multi-district litigation proceeding, I had the benefit of working with dozens of some of the best relator qui tam firms in the country. They were also, a lot of them were plaintiffs class action / qui tam whistleblower firms. And so I was, really impressed by the bar. And I always knew that one day I would join the plaintiff's bar. And I consider it, I'm sure Josh feels this way too. It's the same side, right? We're on the same side as the government. We are their co-counsel, their co-plaintiff. We are their partner. It's a public-private partnership. So it was inevitable that I would eventually join their ranks. And
Renee, you brought up the AWP cases. A lot of law firms came together to help the government in moving those cases along. Jim Breen was involved in that. I know a lot of other law firms based out of Josh's world down in Texas joined forces to help move those cases along. Can you talk a little bit about why that's so important? Why, it's a lot of people call, whistleblowers kind of tipsters, that it's not really a tipsters program, especially when we look at cases like the AWP cases, right?
What most, average people think about as a tipster is you make a phone call, you report some information. You may have one conversation with someone in law enforcement, and at the end of the day, you get some kind of a reward for your tip. It's nothing like that, as we all know. In this space, when we were at DOJ, we worked hand in glove with the whistleblower bar, especially on the in a multi-district litigation proceeding like the average wholesale price MDL. You had dozens of law firms putting in their attorney time, their attorney resources. They put in significant amounts of money. Most of the average wholesale price MDL cases were not intervened in by the government. Only a very small number of them were. Other than those handful of cases, it was really those relator law firms headed by Jim Breen, a single solo practitioner at the time, who brought those cases, funded those cases, resourced those cases, and at the end of the day, recovered billions of dollars for the government. That was all money that went back into the government coffers. So it was in the public interest. And as a result of that, I think it was an 18-year effort from start to finish when all was said and done by the time the last case was resolved. So arguably, they probably put in more money and resources and time than the government. Because again, as I've said, the government's never going to have all the resources that it needs to litigate fraud cases.
Josh, question for you. Same question I asked for Renee. Why did you decide to join the whistleblower bar? You had this remarkable career at the Justice Department. Your reputation was well known in our bar, and then you decided not to join the dark side, but to join our side. Why did you decide to join the whistleblower bar?
Well, I grew up in a family of plaintiffs' lawyers. So for me personally, that's sort of something that's always been sort of part of my legal DNA. When I was with the government working with Relators Bar, I saw, to build on what Renee was saying, maybe 80% of the cases that we were declining had nothing to do with the merits of the case. We were severely under-resourced. We were not a significantly, at least when I came in, well-resourced ACE unit. We tried the best we could to hire, but that's always, you're always competing for spots and for resources and for money and for people. I saw cases in particular that needed to be litigated, and we had some really good partnerships with, firms, some big firms, some small firms, to litigate some of these cases. Even in decline cases, where the government was still involved in watching that. I saw an opportunity to build on what Jeb and you guys have done. Really sophisticated relators work on decline cases in particular. I work with some amazing litigators, and like Renee said, it is a very costly, very time-consuming process, and we choose our cases very carefully. But there are a lot of cases that don't get looked at because there's not enough resources, even on the relator side, to pursue them when the government declines. So, philosophically, it was a great fit for me. I wanted to continue doing the same type of work I was doing as an AUSA. I feel like I wear the white hat every day. But rather than having an agency client, now I have whistleblower clients who are really passionate about what they saw, what they did, and they're very involved in the process. And a lot of times, it's their livelihood. They lost their jobs. And this is a very significant, if not most significant, event in their lives. And that was something that was important to me growing up in a small town, to have clients that I could actually try to advocate for and to make a difference in their lives, while also helping return money to the United States government.
I really appreciate you putting a personal face on these cases. Always keeping in mind that it's not just a name, right? These are people's lives that we're taking into our hands to try to guide through this process. So, Josh, when you make a decision about whether or not to go forward, once the government decides they can't intervene for whatever reason, time, money, resources, the court's putting pressure on them to decide they're not ready, and you're at this crossroad with your client about whether or not to go forward without the government, What are some of the things you think about at that point?
Well, there's a process, that even leading up to the filing where you're counseling your client that under the False Claims Act, the relator is almost certainly not going to be anonymous. That's very rare. To build on what Renee said, it's not a tipster. It's not a anonymous call in and then, you kind of fade to black. The relators are very involved. Most of the cases we take that are original cases, we fully intend to litigate whether the government intervenes or not. And those decisions are really, you don't really know. You know a lot about a district, you know a lot about a particular AUSA, but you don't necessarily know what's on their plate. For instance, we filed cases and then the pandemic hit. AUSAs were working from home. They didn't have access to as many CIDs or as too many agents or as too many investigators that they might normally have. So those cases are taking longer. They may be declined just for that reason. Our judge may say, this has been under seal for now a year and a half, and the relator deserves his or her day in court. So when the government declines our cases, and it's only happened just a very small amount of time in our cases, but we have already, pretty much made up our mind that, we're going to continue to litigate. We get hired quite a bit from smaller shops that have declined cases that need a little bit of litigation resource. And those are, it'd be very careful and, very selective on those. And it's kind of like being an ACE attorney in AUSA again, of going through the decision-making matrix and what, the facts, the court's opinion, if there is one, who the AUSAs are, the, ability to pay both on, on both sides of the V. And, but for us, it's the same thing you would in any plaintiff's case. You're looking at the merits of the case. You're looking at the background of the case, because we don't want to waste our time. We don't want to waste the relator's time. And we certainly don't want to waste the court's time.
Renee, you spent so many years at Maine Justice. We, of course, knew you before you decided to join our bar. Your reputation is stellar. When you decided to join our side, I'm sure you had some preconceived notions about what things were going to be like. What surprised you the most?
Well, thank you for that kind compliment, Jeb. I think that my partner, Eva, and I have a partner who left DOJ with me. As you know, Eva was the senior counsel for healthcare fraud in civil frauds. And together we work on all of our ETAM docket. And I think we've both said this many times over the last several years since we've been relators counsel, that I think what has surprised us the most is the relators themselves in a number of ways. To be perfectly frank, when we were at DOJ, we were so focused on the case. We were focused on, making the legal elements. Is this a good fact? Is it a good fact pattern? Dealing with the defense counsel, that we really didn't actually, I think, appreciate enough the actual whistleblower, the individual. Sometimes it's more than one individual, and sometimes it is an entity, but they're all people behind, every whistleblower, and many of them are just single whistleblower employees. And we have been super impressed by their dedication to do what is right. Most of them, if not all of them, who are insiders, have raised their hand about whatever the issue is time and again for years, and were either ignored or chastised or retaliated against. And most of them, in most of the cases, the issue involves people, right? So in the healthcare cases, it's often patients that are not being treated properly or that are being harmed. Or, with government contracts, you see a lot of military contracts that are, being defrauded, and that involves often military personnel that are put at risk. So at the end of the day, it's always the government funds, right? So it's taxpayers at the end of the day who are footing the bill for all of this, misspent money and this fraud. So I think that was the biggest surprise to us, is how dedicated these individuals are, because I think we didn't give enough credit to really paying attention to what they have gone through and how much work they're willing to do. Most of the whistleblowers that we represent are working, all through the years to help the government with the case, doing all kinds of things to continue to help them. And they stick it out, and most of them are incredibly patient, and they really just want to see a just result at the end of the day. So I don't know if it's such a big surprise, but I wish that when I was at DOJ, I had appreciated that more and paid a little bit more attention to the individuals behind the case that was brought to me.
Renée, I'm so glad you brought up that point. We have a lot of listeners that work at Main Justice or they're working in U.S. attorneys' offices across the country, and I'm hopeful that this show shines a light on that very aspect. Right, that the whistleblowers, their story and what they go through is truly remarkable, admirable, and it's what really drives the whole engine of a lot of these cases. So I really appreciate you bringing that up, Josh. If you were made Attorney General. Matter of fact, I think Biden might announce that at any moment here that you're going to be stepping into those shoes. What would you like to see change, improve, or at the Justice Department or across the country? Is there anything that you would encourage the Justice Department to do a better job of or continue doing what they're doing?
Yeah, I guess let me start where Renée left off, which is, and I will agree with what Renée said. I don't think that, I can speak for my prior district, and I can speak for other districts I worked with. There was not very much focus on the relator's path and the relator's story. When I came to the relator's bar side, the key team side, I really have been impressed, like Renée said, with who these people are. I think maybe at the DOJ, there's so many cases that the department attorneys who, again, are understaffed and overworked, are trying to go through. And not every key TM case, I'm not sitting here to tell you every key TM case has a righteous story. I mean, very, very, very small minority. You may have somebody who, probably shouldn't have brought the key TM. But these attorneys are going through and trying to, figure out which ones are meet the law, trying to work with agency counsel. They spend a lot of time on the telephone with all the interested parties and interested entities. So I guess one thing that I think the department could do better is realize the resources that the Relators Bar has, realize the expertise that the Relators Bar has. You asked me one of the reasons that I decided to go on this side of the B. People like Renée and Eva and people before them were trailblazers on this. I mean, they showed that there is a room and a place for sophisticated former DOJ lawyers that can come in and help guide sort of the next generation of AUSAs. Some offices are recognizing that. I've got a couple offices with fairly young AUSAs who are asking for advice. How would you investigate this? What types of documents would you want? I don't understand necessarily the ins and outs of the Stark Law. How does this apply for the False Claims Act? I think focusing on the FCA world and the civil world that we can and what we can bring back and the recoveries that both the Relators team and the ACE teams and Main Justice can bring, I think there can be better collaboration. Now, you kind of put me on the spot. That's not something necessarily that's overarching policy issue that the Attorney General would come in and be first on his list. But that's something in our world that I think that we can do a better job. And I think that paying attention to some of these issues that are happening with the proposed amendments to the False Claims Act, I think we're on the right track. This is not a time to take the foot off the gas. We have record spending. With record spending comes a lot of fraud, and the two teams ought to be working very hard and diligently together.
That's a great point, Josh. You're absolutely right. Trillions of dollars have gone out the door in the last year to help us through this pandemic and increase expenditures for civil frauds in the U.S. Attorney's offices and the ACE coordinators across the country certainly is needed to make sure that we protect those dollars. So I echo that point without a doubt. Renée, I oftentimes ask this. We have, without a doubt, someone who's listening to today's show who's working at a company that might be doing things the wrong way, might be jeopardizing the lives of patients for the sake of physician greed as opposed to patient need. And these people are potential whistleblowers. What would you say to these individuals?
I mean, frankly, I would tell some whistleblowers to come sooner. I don't think that I've had a single, even a single whistleblower, even the cases that we've turned away because they're not meritorious or they're not False Claims Act cases or whatever the case may be, that saw something and then went to a lawyer. It just doesn't happen. Whistleblowers are people who have been thinking about the concerns that they have, raising the concerns that they have, having sleepless nights, being incredibly stressed out before they call an attorney. It's just not an instinct that someone has. It's usually a last resort for most people. And a lot of people who come to us, they're afraid that they're in jeopardy because they say, I see what's happening. I feel like I'm a part of it because I work here. Sometimes they're being directed as part of whatever the fraud is, and they're worried about their own liability. A lot of them actually make reports to HHS OIG hotlines or the agency hotline. So they've usually reported things somewhere, and then things get really bad for them. Sometimes they're fired, and then they come to us. A lot of them have something happened even a year or two after they left, and it's still troubling them. They're keeping in touch with the folks who they used to work with. They find out that the conduct is still happening, and then they say, it's reached such a height of troublesomeness that they then call an attorney. So in the first instance, you see something, you say something. That's a good moniker for all of us in every space, including for whistleblowers. You should, of course, speak up to your first line supervisor. And if you're at a big company, often, and there should be today, I know there's not always, there should be a channel for reporting complaints. Some are valid and some are, we all know, are really not valid channels. No one's really at the top listening to whatever complaints go into the system. But obviously, you should be trying to fix what's right in front of you to the best of your ability with whatever power and authority you have. You shouldn't wait 3 or 4 years to get your nerve up to call an attorney. And a lot of times I advise, I'm sure Josh is in the same position I am, we often advise people and then turn them away and say, you're not going to file a False Claims Act case, or we're not going to file one, and we give them reasons why. But often they've waited too long. They've waited years to come to an attorney. At that point, they may not have what I call hard evidence to bring to the Department of Justice because they've left the company. And sometimes they just wait too long because it's scary process for them, and they're not really sure what to do. So I think they should, think about calling an attorney before too long, before the conduct and the false claims have been submitted to the government for too long of a period of time.
Very well said. The whole see something, say something moniker should be expanded, right? It's see something, say something, do something. Maybe that should be added to the end.
Right.
I'm always struck a lot of times these cases involve very large multinational companies. A lot of people know what's happening, but very few people step forward. Maybe 1 or 2 people decide to take that last step of doing something. Josh, why do you think so few people take that courageous last step?
It's agonizing. I think that these individuals who become whistleblowers, they weren't born that way, right? They didn't go to elementary school and middle school hoping to one day become a whistleblower, to see something wrong around themselves and potentially jeopardize their jobs and their careers. They are people that have integrity. They think things need to be done the correct way. And like Renée said, it is very, very, very rare for a whistleblower to have one day of experience of something that they see, think that they can go make a lot of money and go to an attorney. That's not how our clients operate. And there may be a threat of that amongst maybe the American public or the defense bar, that's all it is somebody out there trying to make a payday. That's just not true. It's hard to judge my clients who, when I ask that question, why didn't you come, get a lawyer or me or anybody else sooner? And people don't want to believe that the people they're working with are doing these things. They don't want to believe that the organization that they decided to apply to work for, the mission that they've bought into, are doing these things. And so I think some of it's the time that's required and the evidence, whether hard evidence or just circumstantial evidence that they're building in their minds to make sure that they're doing the right thing, which I think is great. But like Renée said, I think that they could benefit from maybe seeking counsel sooner. And one of the great things about what you're doing, Jeb, and what TAP does is to educate would-be whistleblowers on what they can do and what their resources are. Because I don't think a lot of people know where to go or what to do. And I think in the forefront of their mind is, even if I wanted to hire a lawyer, I can't afford one, right? So, and as far as once people get past that process, there's a real sort of life altering decision to make. I think some people say, you know what, I'd rather just go ahead and resign. I'll go work for somebody else. Maybe their family and friends are saying, look, you don't want to do that. You don't want to be, in a lawsuit. This is a big, powerful company. They'll fire you. You'll get blacklisted in the industry. So maybe they get talked out of it by friends and family. And look, when we counsel would-be relators from the front end, we tell them, it's not without risk, and there could be publicity. It could be a years-long, litigation. It could. A lot of our cases will end up in appeal and come back. It's not unusual to have a case that lasts a decade. And so some people don't want to do that, but there are ways to stop it, to stop the fraud, to make a difference, short of filing a False Claims Act case and being a relator. But as far as the type of personality, what makes somebody actually take that final step and not, I think it's just a multi-factor thing, their upbringing, where they are in life, how much they have as far as potential downside for doing it. And most of the people, I think, who don't want to take that step feel like they have too much to lose.
Josh, you raised a very good point. A lot of people are concerned about, they can't afford a lawyer. As Taxpayers Against Fraud, we encourage our member law firms to take a contingency practice when it comes to charging clients, so that the client isn't coming out of pocket right out of the gate to pay for a lawyer. And we certainly encourage our member firms to do that for that very reason. We want people to step forward without the concern of, do I have the money to hire a law firm to represent me? Renée, your experience to the Justice Department, how does that help you in assessing a potential whistleblower case?
Well, having worked there for so long, and vetted so many cases from the receiving end of being, at the DOJ, receiving the case from the Relators Council, which I now am, and the whistleblower team. I think a few things are probably true of each of us, like me and Josh and Eva and others who have been, worn that hat, and we also bring different experiences to bear. So my experience is not the same as Josh's and not the same as Eva's, but I think a couple things we know, having worn the hat, having sat in the seat, we know what the prosecutor needs to get the case going. We know what will motivate a prosecutor. We know what will not motivate a prosecutor. We've been through it for such a long period of time. So I think we know how to package cases. And Josh and I have actually talked about this a little while back. I always call it the gift package, right? You need to put together a gift package. And what I mean by that is we know that the prosecutors have too many cases and that they're not going to be able to investigate everyone that they're assigned. I don't actually think that's even a secret. It's an open secret, maybe. The prosecutors cannot, it's just impossible to investigate every single case that comes across their desk. So to the extent that you can put together a really nice package by including all of the documents that you have, what I call the hard evidence to support the allegations, you number them, you put them on an index, you make it really easy, you tie your documents to what is in the complaint. So when you have a sentence or an assertion or a paragraph in the complaint where you're making an assertion of fact, you tie it to the document, whatever is the hard evidence. And if it's not based on a document, you tie it to your relator, your whistleblower, your client's anecdotal evidence, their experience, their firsthand knowledge. So you put together, a really nice package. You include a roadmap, just as Josh said a few minutes ago. You put together a roadmap. So, of course, as Relators Counsel and former government prosecutors, we have already thought through how we would investigate the case if it landed on our desk. So, and we come up with a theory, right? So, Josh and I know when we were looking at a case that didn't have a nice gift package, that didn't do those things for us, we had to think about, what is the legal theory of this case? We had to sort of figure it out on our own. And if you have thought through all of that, and you should have as a Relators Counsel, you should have thought through what your legal theory is of the case and how the facts support it. You tell the prosecutor, at the first opportunity, here's what I think is the legal underpinning of the case. Here's how I think you investigate it. And you You can do that in a number of ways. You should also put together witness lists. So, of course, the employee is going to know 10 people at the company who they've spoken to about the concerns they had, or whether or not they have spoken to them, they know others who are sitting in the right seat in the company who can answer for the prosecutor questions that the prosecutor would have. So you put together, including in that package, I call them a witness, but it's really just an employee who can corroborate what your client has said. And so everybody has a different way of putting together that nice package, but more that kind of spoon feed the prosecutor, knowing that they're really busy. You give them something that they can easily understand. It's understandable to them. They understand your legal theory. They have witnesses to corroborate. They have the hard evidence that your whistleblower has. They know where it's anecdotal. And also you tell the prosecutor, here's what I don't have, right? I may not have a specific claim because my client wasn't the claim submitter, but I can tell the prosecutor, I'm going to be really honest with them right up front. We have materiality problems. We have scienter problems. My whistleblower doesn't have that information. And so you also let the prosecutor know where are the holes in the case so that they can, they're going to find it eventually. It's kind of foolish and you lose a lot of credibility if you hide that at the outset. They spend 6 months trying to figure it out and then they find out something you didn't tell them. So I just call that a gift package because I would have liked to have received more gift packages when I was a prosecutor. And that would allow me to take that case and run with it faster than I might another case that didn't give me all of that, good information. And I'm not only starting from scratch, I'm kind of starting in a hole. So I think that's what Josh and I bring to the table. That's what I think is helpful when you work with us.
Yeah, Jeb, just to jump in real fast, just for any AUSAs or defense attorneys on my cases that might be listening, there are no holes in my cases.
That's what I heard. Well, it's funny. Years ago, I talked about in kind of training people on this area that you want to try to present your case as if this is low hanging fruit. And another person on the presentation with me from the government said, "No, Jeb, we prefer box fruit, not low hanging fruit." So if you're able to present it as a gift package or box fruit, there you go. Josh, what do you see? You've seen it from defense side, spent time in big law, and then you went to the government, now relator side. What are some of the mistakes you've seen relators or whistleblowers or whistleblower attorneys make over the years that you certainly don't do in your current practice?
Yeah, and first, let me take the opportunity to say, even when I worked at a big law firm, I cut my teeth on healthcare regulatory work. Most of what I did was plaintiff's work. I actually chased doctors around the country for hospital systems to recover money that was owed to the hospital systems. Primarily driven by regulation, right? Stark law in particular. So I got to work on one defensive side QTAM case that was declined. Which I think was beneficial, right? To see it from that end, from the government's end, and from the relator's end. One of the things that relators attorneys need to be thinking about, and I saw it when I was with the government, and I really try to make a good point of focusing on it at the outset of a case on this side, is two things that kind of combine. One, that there's a tendency to listen to a client and think, okay, they just told me 15 things that could be possibly a lawsuit. I really like these 2, 3, or 4. These other ones could be something. I'm just going to go ahead and put that in a complaint. Well, when an AUSA or a trial attorney at Main Justice sees that, if it's not packaged correctly, an already under-resourced staff is going to look at that and say, where do we start? What's really going on here? So one thing I think that should be done is to really understand the facts, really understand the law, and to really focus on the key aspects of the case rather than, potentially throwing in things that could be breadcrumbs but might not lead anywhere. The second thing is a lot of relators attorneys, I think, miss a really great opportunity to submit a strong disclosure statement. The complaint's written for 9B purposes. It's written for the complaint. It's a different audience. And a lot of relators attorneys used to just repackage the facts section and send that in as the disclosure statement. I think that's a real mistake because I think the disclosure statement is really the first opportunity for an AUSA to read a narrative. And I tend to do mine in a little bit less legalistic and more communicative. As somebody who might want to read an interesting story, don't spend as much time on the law in the disclosure statement. Because that's already there, and we all have our 10 pages, 15 pages of law in the complaint. And then I think the other thing is when I was on the government side, a lot of relators attorneys were great to reach out. I wish I had more time. I wish I had known at the government what I know now, which is that a lot of the relators attorneys could have helped me more in the investigation. We were not particularly quick to jump on asking relators teams for help. I think towards the end of my term, I started to realize that was something that would be beneficial. But now on this side, I think that it's something that I see just how many resources can be brought to bear on the private side to help investigate these cases. But as far as the relator side and things that I would recommend, those are the two that primarily, in my mind, are first and foremost. And they're important because that's when the case is first getting looked at, and it's when it's first getting off the ground.
Great points. Renée, you recently wrote an article with Jackie Namar out of Taxpayers Against Fraud, addressing some of the misconceptions that the defense bar have about how things actually operate, the Justice Department and the Relators Bar. Can you touch on what those misconceptions were and what the realities are?
Sure. So there was a Law 360 article by, and I myself wouldn't say it's the defense bar, because I have plenty of colleagues who left DOJ with me. And I communicate with them all of the time, and they don't see it as that Law 360 article was written. So I would say certain authors of a Law 360 article made an argument that the government should consider dismissing all declined qui tam cases. And Jackie Namar at TAF and I made, a counter argument to that, and we feel very strongly about it. And I certainly do, having worn, again, most of my career, my hat was worn in the government, not outside on the private side. The DOJ, and it all surrounds the Granston memo, right? So that's the memo. Michael Granston is now the Deputy Assistant Attorney General. He is the longtime head of the fraud section enforcing the False Claims Act. He is really a visionary, I would say, of the False Claims Act. And Michael wrote a memo outlining certain factors that a prosecutor can and should consider for declining qui tam cases. And that memo urged judiciousness in the government making that decision. The government itself, and I can say this having worked there, again, for a very long time, the government itself recognizes that it needs the relators to litigate certain declined qui tam cases. There are, on occasion, and I've been involved in some of them myself when I was there are occasions where the government's interest is not going to be met by pursuing a case. It's nothing personal against the relator team or the whistleblower team. It really is often a matter of legal determination. So often the DOJ internally says, much like, frankly, the Supreme Court might, this is not the right time for me to decide this particular issue. And so often DOJ says, we don't think this is the right time to litigate this particular issue at this time, maybe in the circuit that we're in, or maybe the government thinks that this is a very challenging legal issue, and perhaps the fact pattern of the particular case that's going to be, raising this issue for the first time at a district court and an appellate level. DOJ would rather wait to see a better fact. There's a whole bunch of reasons why the DOJ wants to consider declining qui tam cases. They've done it again. They have been incredibly judicious. As we pointed out in the article, there have only really been about 40 cases that have been dismissed out of thousands of cases since 1987. And I say 40, even though the number 50 is often floated, because 11 of those cases was the same relator with the same repeat legal theory against the pharmaceutical industry. So I consider that, all those cases were dismissed for the, obviously the same reason internally. So I think that's a huge misconception that DOJ would ever consider that, because DOJ would never consider moving to dismiss every single qui tam case. They believe that a lot of relators counsel, often I'm asked now as a relators counsel, would we, my team, would we consider litigating this on behalf of DOJ if they don't have the resources? We are encouraged to do that. And I know that in all the cases that I have those discussions with the government, I always ask them, do you want me to litigate this on your behalf? I'm not going to litigate a case where DOJ is opposed to that. and certainly not where DOJ is going to dismiss it. I know there can be occasional, but it's pretty small. I think the number of times where Relators Counsel and the government are going to, disagree about that. But I think it's a big misnomer. The DOJ would do that, as a matter of fact. So I also think it's a reckless argument for someone to make, because the Relators Bar recovers significant amounts of money in declined key TAMs on behalf of the government, just like in AWP. AWP recovered billions of dollars in declined key TAM cases. And while we did assist those relator teams in a significant way, they outnumbered us, the relators law firms, in terms of their resources and their numbers. And we would never have said no to AWP. In fact, we asked those teams to do those cases on our behalf, and they did. And that's just really, I go back to that one example because I spent 5 years on that piece of litigation, and I know how necessary it was for those relator law firms to bring those cases. So I think that's it. That was a reckless comment, and DOJ won't go public in responding to a Law 360 article. But if they could, I am confident that they would agree that their goal in the Granston memo was judiciousness and not, taking just a slash to every declined key TAM case. That would be terrible for the taxpayers.
Hey, Jeb, can I jump in on something?
Yeah, please.
Because one of the things that my interpretation of that article was that they were really focusing on the recoveries in declined cases, which I think is a misplaced and potentially dangerous argument. A lot of times the DOJ declines cases that are smaller damages, and not smaller in the public's eye. It may be, $3 or $4 or $5 million. That's not a small recovery. But when you're under-resourced and you're focusing on the $40 million cases as an AUSA, that might be one reason why you decline. After the Granston memo was issued, it became sort of a cottage industry, or at least a standard maneuver, to try to meet with government lawyers and say, you need to dismiss this case. That bar is high, and it should be very high. We very, very rarely ever consider dismissing cases. And here's why. Relators team comes to you and you're going to decline. The relators attorney is asking you questions, just like Renee and I do on this side now. No competent relators attorney is going to hear the DOJ say, look, let me show you why this case is bad. You don't have the facts. This fact is really bad for you. You're not going to get past 9B, or the law just doesn't support you. Those conversations are being had, and the vast majority of the time, the relator will voluntarily dismiss the case because they're listening. Point number two, that argument really cuts out one of the core decision makers in our judicial process, the courts. They're there for a reason. And to me, it's a sort of a shortcut of let's get the DOJ just to start dismissing cases. Let's lower that bar. Let's get these cases out of here, rather than relying on the courts to make the determination when the defense bar has 9B at its disposal. If fraud isn't alleged with particularity, the courts know the standard and the court can dismiss it. To me, those arguments often ignore the purpose of having courts in the first place. And I think that's just something that kind of is in the background of those arguments that kind of bothers me.
These are great points. The other thing I wanted to highlight is, there's been a lot of good case law brought by Relators Counsel that have continued on with these cases without the government. Sometimes, as Renee and you talked about, Josh, at the encouragement of the Justice Department. Off-label marketing cases would not have happened but for a decline case going forward, getting good case law, and then subsequently billions of dollars in both intervene and decline recoveries under the False Claims Act. There's several other examples where the Justice Department just wasn't at the position to move forward with the case, and good case law happened. Subsequent recoveries happened, and billions of dollars recovered. So, the arguments made by a few select members of the defense bar simply don't ring true. And I appreciate Renee and Josh clearing that up on today's episode. Renee, Josh, this has been a ton of fun. I acknowledge both of you guys for being real leaders in our bar and always willing to educate people from all sides about how things operate under the False Claims Act. I really appreciate your friendship, your guidance, your encouragement as you guys joined our side. It really is a benefit and asset that you guys joined the Whistleblower Bar. And I really appreciate you joining us on this episode.
It's been an honor. Thanks, Jeb.
It has been an honor. Thanks to Josh and to Jeb.
Well, guys, make sure you join us next week when we dive even further into a very interesting topic under the False Claims Act on the next episode of Fraud in America.
If you believe you've witnessed fraud against the government at your job or want to learn more about these important laws to combat fraud, visit fraudinamerica.com. On our website, you can find whistleblower lawyers, logs from these expert attorneys, and more. You can also find a transcript of today's show notes, a way to contact our team, and a way to chip in to make sure we can keep bringing you the latest on fraud. This episode was edited and produced by Rachel Brooks, and our theme music is by Connor Chaos. A big thanks to our staff and researchers of Jeb White, James King, Emma Bass, Jackie DeMar, Kate Scanlon, Brian Markovitz, and Max Boltman. You can learn more about them at fraudinamerica.com/team. Fraud in America is a project of Taxpayers Against Fraud Education Fund.